Hi, my name is, hi, my name is, my name is, my name is, and I never even understand. participants or your speakers speak into here, and this is actually going onto the stream online, although it doesn't project here. Or I can take that out and capture sound audio, or rather room audio, which isn't going to be as good. We just have one. If you had one what?
He said there was like one would be in his right ear, one would be in his left ear, and then maybe two.
Two mics. The only issue is I have to go find a second mic. I'll go see if I can find a second mic,
Okay.
and I'll get back to you in 15 minutes.
Okay. Yeah, that sounds great.
Testing, 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 testing. Let's check the online stream, verify. Testing, 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 testing. Testing, testing. Testing, 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 testing. Testing, 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 testing.
I don't know, listen, I'm just throwing out an idea. Good idea. I don't even know if we need a microphone in there.
Well, we do have to have the microphone for online folks. So I want to welcome everyone. Thanks so much for coming. I know it was pretty difficult to find this room, so congratulations for making it through the maze to get here. There's no speaker, right, but it is for the online folks. So if you do contribute some comments or questions, please make sure to speak directly into the microphone to make sure that our online folks can hear as well. Thank you so much, and also those who are online. This is a forum on AO 2223. A lot of you attended via webcast or in person at our last year's event where we had kind of the two sides where we talked about it. This is a continuation of that. Maybe not so two-sided and maybe more one-sided here, but I'm very privileged to introduce Jeff Bean and John Schaefer, who are our moderators / speakers for tonight, and I'll have each one of them introduce themselves. For those online, please remember that you can contribute as well through the chat function on YouTube. So please do. I will read them in the room live, so you can participate in real time.
Okay, so my name is Jeff Bean. I think I've met everybody in the room before or today. I am a facilitator and a mediator. Been practicing law for, I don't know, added up, it's measured in decades. But I've been a full-time mediator and facilitator for a while. The last time I got involved with this, I was moderating a panel of a couple of folks where we discussed Advisory Opinion 2223 several months ago. Can't remember exactly when it was, and there were a lot of good discussion there. What I'd like to do is John and I have talked, and we thought it would be useful for us to sort of give you our background that colors, and you could even say skews, our various perspectives on this. I'll just warn you, if you were looking for point counterpoint, as much as John and I would love to do that, you aren't going to get it from us. But I think it is going to be, and maybe contrary to a point counterpoint, hopefully a useful and informative and maybe even encouraging conversation, and with some possibilities for what might happen next. So what I'd like to do is just beyond that, I'd like to have John introduce himself, and then if you could give your perspective, and then I'll give mine, then we'll move on to it. We really do want to make this into a conversation, but in order to understand maybe where we're coming from and why they put this moderator thing on our name tag, we thought it might be helpful for you to have that.
Thank you, Jeff. I don't know for our online people, do we have any idea if there are people online? 7 people online. So for those of you who are joining us online, welcome. And for all of you who I at least had half a moment, I think, to say hi to, we have a lot of intelligence in this room, and we've got some senior members of the bar and one younger, considerably younger member, which is good because we live in an age where we oldsters, at least people my age, and I would guess I might have the edge on most everybody here, need the ideas of what it's like to be practicing law now and what it means to be a mediator or an arbitrator or the various careers you all might have followed. It would be nice, I don't know if it would be comfortable for you to have you all just take a half second, just tell us who you are and our audience and what you do.
So my name is George Shashinsky, and I actually only passed the bar last year, so I'm actually kind of young as well.
Well, welcome.
And currently I actually work professionally managing IP for a large nameless corporation.
My name is John Butler, and I actually also passed the bar last year, so my perspective is also skewed that way. But I'm a staff attorney in-house at a company called A Place for Mom that does senior housing referral. And I am not a mediator, however, I do have a background in ADR from several years at the AAA.
Hello, everyone. My name is Bruce Marshak. I have been a member of the Bar of the State of Washington since 1977. I was lured away to a job elsewhere, and I am back to build a mediation arbitration practice primarily in the southern part of the state, Northern Oregon. I attended this discussion last year online and made a determination that absent a change to the advisory opinion, I would refrain from doing any matrimonial mediations in the state of Washington. And the reasons for it are, I believe, that it damages people who would like to have a person with a legal background do a divorce mediation for them, because it puts them in a position where they have triple their costs. They need to get the work done, and then they need to go to 2 other lawyers to get it done. It creates a disadvantage to people in that situation, and it makes people who want to earn a living as a lawyer mediator in that area non-competitive. A person walked through my door and said, "Bruce, we're in the state of Washington. I would like for you to mediate our divorce." I would feel ethically obligated to tell them it will cost you 3 times as much money probably to use someone like me than to use a non-lawyer mediator. I think that's a disservice to the community and to the bar.
I'm Pete Day. I am I won't say full-time. All I do is arbitration as an arbitrator. I teach international arbitration at UW. Before that, I worked in-house at Boeing for 25 years, and in my really misspent youth, I was a civilian and military prosecutor.
Hello, everyone. My name is Roger Moss. I'm not currently a member of the Washington Bar, but have been admitted in California since '86. However, I never practiced law until recently down there. I had a business career, and the guts of it was collaborative negotiation and relationship building and commercial real estate, and that led me to conflict resolution. I went back home to the Bay Area 3 years ago to open a consulting practice and a mediation platform. I focus on anything to do with real estate, family business transition, and any conflict aggravated by behavioral health issues. I've recently moved to the Puget Sound for family reasons and have been connecting with everyone, first with the King County Bar Association ADR section, and joined this group, which I'm very pleased to be a part of. And I'm here tonight because I read the opinion 2223, and I'm interested to hear what you all had to say. I can tell you down in California, people are doing exactly what that opinion seems to prohibit with great success. And I'm a supporter of non-attorney mediators, and I work with them often, and support on making things easier for people to get things done in the justice system with our help. And so in California, I've learned recently more about unbundled representation, unbundled services and limited representation, and those things coming together with collaborative law and mediation to help people get things done right and peaceably and very affordably. So that's my story.
Hi, everybody. I'm Helen Ling. I've conversed with a few of you prior to this event. I'm on the ADR executive committee and helped put together this event. I wanted to also introduce some people online, or actually just one person so far. So Paul McVicker, he's a family law mediator and litigator, promoter of early mediation and child-centered mediation.
Hi, Paul. This is a small group tonight. For those of you who are online, one of the things Jeff and I thought would be good would be to ask what questions you all might have. And if you could text those in, they can be half-formed ideas. Matter of fact, that'll be part of our format tonight. I think we can, because we are small. Let's find out what's relevant to all of us at the appropriate point, and then we'll kick ideas around. And certainly the one you raised about what does the advisory opinion mean for lawyers, and is it relevant anymore? I like to think of AO as standing for awfully obsolete. And by obsolete, I don't mean disrespect for the law, because I think there are really tricky situations. By the way, I'll give my background in just a second, but I want to kind of start with this comment. I think there really are tricky situations where you can get into a situation with two legally uneducated people, maybe not even a couple that has a much of an advanced education, where the intricacies of the law and what their rights might be and how that might influence an informed decision would be really tricky to handle, even if you were to try to get informed consent, which is one of the things I think we want to talk about tonight, because our rules do provide for written informed consent by people to potential conflicts of interest. But you can get into a tricky situation. And so Jeff and I want to talk a little bit about what the tricky problems might be, as well as what we think the more innovative solutions, which are contemporary to a legal future that has swept in on us, and for me, being as old as I am, swept right on by me without my ability to grasp it. If I were to try to practice law now, there'd be no way I could do that. Technology, I just did my will, and I did it through LegalZoom. And there's Legal Rocket or Rocket something or other, Rocket Law, and people can get online now what we used to make a living at, which is a valuable public service for the clients we serve. And how the law and lawyers and those of us who learned how to think like a lawyer, which was a major challenge for me, how are we going to adjust and help people who have issues that raise legal elements in them come to the right kind of solution for them without forcing them through the expense of 3 lawyers? And can we do it, and how might we do it?
John, I'm just going to interrupt you. We also have Rena Goodman online and Leslie Blankman, just to let you know.
Well, hi, Rena, and hi, Leslie. Yeah.
Maybe I'm the only person in the room who hasn't read the opinion. Would it be possible to give a thumbnail sketch
Sure.
of what
You-
this is?
Yeah, you want to go ahead? Sure.
I can do that. First, to give, and the quick perspective on where I come from this, I feel like I'm in really exactly where I like to be in almost any situation, which is perfectly disinterested in the outcome and intensely interested in the conversation. And that's because I don't practice in family law, matrimonial law, divorce, however you want to term it. I don't do that. I am a full-time neutral, mediator and facilitator, but I don't write agreements. It's just the nature of my practice. I don't do it. I haven't intended to do it. So it really doesn't affect my life really one whit. But I'm intensely interested in it for similar reasons that John is interested in it. This is the way things are going. And I think there needs to be some way in which our very traditional and historical and backward-looking system of Anglo-American jurisprudence should be able to accommodate these innovations and these changes. And it's going to happen. It's just a matter of when and how. So I'm very interested in that. I'm sympathetic toward the problems that my friends and colleagues who are lawyer mediators in divorces are dealing with. And I'm very sympathetic to that, and I understand the realities of what this opinion portends for them. So as a quick overview of the opinion, this is Jeff's understanding of it, and please feel free if someone wants to correct me or fill in the blanks. The opinion is an opinion of, I think it was called the Committee on Professional Ethics, CPE, I think. It's now been changed. It's something else, whatever the committee is called within the Bar Association, that deals with these issues. And for some reason, somebody raised the question of, is it ethical for a lawyer mediator to write up the documents, and this is where my not doing it, whether it's the petition or the final orders or whatever in the case, this is where not doing the case I'm going to miss on the specifics, but is it okay for that lawyer mediator to write up the documents that then create the legal effect for that agreement, as a divorce needs to have? This, of course, is a little different from my area of practice, where people can come to agreements. They don't need to be court orders, but that's the way our society works. You want to get divorced, you have a judge put in the order and bang the gavel and make it all official. So can they write those agreements? And the committee says, well, can they write those agreements ethically? And the committee says, basically not. Because, and the quick rationale, as I understand it, is the choosing of documents which affect legal rights and would create binding obligations on parties, the choosing of those documents, the writing of those documents is within, I think it's GR 24, 2.4, there's a 2 and a 4 in it. Anyway, the writing of those documents is the practice of law. And since you are practicing law, the question then becomes whether those people who you're writing the agreement with or for, whether you could represent them both. And they come to the conclusion that you could not, because two spouses who are getting divorced have adverse interests. When the RPCs say interest, that's different than those of us. That's a different word than we use when we're talking about interest-based negotiation. Whenever the RPC says interests, you can read that in our training as interest-based negotiators as positions. But that's the way the conflict of interest analysis goes. So the two parties have adverse interests / positions, so therefore you could not represent them both And therefore, by practicing law, by writing the agreement and representing them both, you are engaged in an unwaivable and unconsentable conflict of interest, and so you can't do it. So that's the analysis. They say it's limited in application to lawyers mediating divorces. I will tell you that the analysis is perfectly consistent, and the slippery slope is greased all the way down to any mediator, lawyer or not lawyer, who is writing any sort of agreement, including when the Jams Whams JDR panel members are pulling out a CR2A out of their form book and saying, here's a CR2A for you guys to resolve your tort case. I think the same reasoning applies. The same reasoning applies to if they were to look at DRC mediators who may or may not be lawyers, but if they're not lawyers, then the analysis would just come to a different conclusion using the same rationale that they are engaged in the unauthorized practice of law. So it should involve and interest all of us who do mediation, that this is what's happening. So that's the synopsis of what AO 2223 does. It is also a non-binding opinion. It doesn't have the force of law. And when we had Jean-Marie Colvert, who staffed the committee who wrote this, she made it pretty clear that this is not the type of thing which we would see bar action based on. So I think that we came to, she would make no promises, and I wouldn't expect her to, but as I say, I wouldn't expect anyone to get a knock on the door from Bar Disciplinary Council because of AO 2223. So I believe the people who are most concerned about it are still doing this, are still writing their agreements, but they're concerned to make a change. So that's the synopsis.
I do want to point out that the UW Law Review article that you had mentioned is on our website. There is a link there. So if you have interest in wanting to read that, please go to our WSBA-ADR.org site.
And give yourself about 4 hours.
Well, the interesting thing is the majority of states that have been reported in 2 law review articles that have now been written, the most recent from New York, which is also, I think, listed. Rena Goodman, who's on computer tonight with us, sent around an email notice, and I think it's posted on the discussion section of our ADR section, of a New York lawyer who has opined on this question of representing couples in divorce. He's got a divorce background. The interesting thing to me when I did my lawyer hat in looking at this issue a couple of years ago, the opinion says the preparation of documents for both otherwise unrepresented parties in a divorce to effect an agreed settlement would constitute representation of both parties in the divorce litigation. And then it goes on to say, representing opposing parties in the same litigation is unconsentable. And it states generally that representation is prohibited if in the circumstances, the lawyer cannot reasonably conclude that the lawyer will be able to provide competent and diligent representation. So built right into the opinion itself is the exception which says we're reasonably talented lawyers who are trying to offer a public service to people who have elected not to go to lawyers to negotiate their agreement for divorce. And building on that, then I started looking at some of the rules that our RPCs provide. And the rule is that 1.7, RPC 1.7 says, requires that the parties be directly adverse, or that there be a significant risk that a lawyer's representation of one client will materially limit his or her responsibilities to another client. Well, partnership formation, a lawyer who represents a corporation, a lawyer who's working on staff where you work. All over the law, there are going to be places where we're called upon to make decisions that potentially affect people adversely. And so I said, the law's got to be smart enough to have provided for that. So it's the direct representation that's the problem, By the way, you can get a divorce online now, I think, through various services. And right here in the Northwest Justice Project, it provides all the documents a couple needs to get and file for a divorce on their own, unrepresented, without any help negotiating their own agreement or having any idea what their legal rights might or might not be. And remember, we're talking about custody issues as well as monetary issues. And we're dealing with people often who are in really desperate straits, physically, emotionally, mentally, and spiritually, because of the conflict that they're going through. So just for fun, and then I'll turn it back over to Jeff, because I know he'll have some things to say, or we'll get your questions. The fundamental principles of professional conduct, which is is found before our RPCs, says each lawyer must find within his or her own conscience the touchstone against which to test the extent to which his or her actions should rise above minimum standards. But in the last analysis, it is the desire for the respect and confidence of the members of the legal profession and the society which the lawyer serves that should provide to a lawyer the incentive for the highest possible degree of ethical conduct. So we're talking about ethical conduct in a new age, in a new era, when legal services, as they once exist in an adversarial system, are giving way to legal recognition in the same RPCs of what it means to be a lawyer mediator. And the services section of the RPCs that talk about serving in that dual capacity, the general rule is, if you're a lawyer, this is 24, the Rule 24, General Rule 24, definition of the practice of law. The practice of law is the application of legal principles and judgment with regard to the circumstances or objectives of another entity or person or persons, which require the knowledge and skill of a person trained in the law. This includes, but is not limited to, as Jeff pointed out, selection, drafting, or completion of legal documents. So we're acting as a lawyer, according to the RPCs, if we're drafting documents, because it requires our legal skill. But then it goes on to say exceptions and exclusions. Whether or not they constitute the practice of law, the following are permitted: serving in a neutral capacity as a mediator, arbitrator, conciliator, or facilitator. So built into our very own system that was overlooked, I think, by whoever it was that wrote the advisory opinion, is room to expand and be innovative in a new era and a new age. And that's what I recommend. That's where my heart is. I got a hunch it's probably in the heart of others here at our table tonight and online. And that's the main point I want to make. The rules are flexible, and this opinion was not. And I think people sense that in their guts, and that's why there's been a strong reaction. The greater reaction in the community seems to have been, wait a minute, something's being violated here. As a bar association, we're missing something. The only thing that hasn't happened yet is any of us have picked up the cudgels and gone to say, hey, we think there's a problem, we should change this advisory opinion. And as Jeff pointed out, advisory opinions are only that anyway. They're not controlling. Now, what they do is they expose you to risk. And some of us are very risk averse. And so we're helping a couple, we get to the point, or we're helping partners who want to form a partnership. And they get to the point where they want to write a partnership document. You're going to make them go to two lawyers who are then going to think about all the horrible things that can happen in a partnership, so they cover it in a 27-page document, when all they want to do is get going with a new business? That's the kind of question we're being asked to decide now as lawyers. And I think there's a lot of room in the rules to allow us to do that. And yes, there's risk. And there's risk. But I'd recommend, I'd hope that as a result of our discussion, you'll begin to feel freer to render people service, and we all have to make that decision. So maybe you'd like to add.
Yeah, what I'd like to do is I'd like to get the questions or issues, and I already heard some of them that right after your introduction. Hi, My name is Bruce, and here's, it's Bruce, right? Yeah. My
can
name is
I-
Bruce, and here's my concern.
Can I just read?
Sure, go ahead. Go ahead.
All right. So before I pass off the mic, since I have it right now, I wanted to read some comments from Rena. She says there's an exception for DRC mediators. Also, she says there's.
Speak up, please. Can't hear you.
Oh, got it. There's an exception for DRC mediators. Also, she says there is a rule that mandates that they draft the parenting plan, in fact. Anyone know what rule that is? And she also says, I don't believe that the online divorces apply to situations in which there are children.
Okay. Mhm. Yeah, yeah. So let's get the issues or concerns or questions. Okay. Yeah, let's get the questions or concerns or the issues that folks had. Get them up, and let's see if we can use them to structure where people, what people want to talk about and have addressed. So,
Yeah, any ideas that are on your mind, they don't even have to be directly on point. I think you can be informal about what are the issues that you're feeling related to this topic that we've now opened up a little bit. What would you like to talk about here?
questions, concerns about the opinion? John, you have something on your face? I see it.
Thanks, Pete. Well, I guess I don't want to play devil's advocate, but
Oh, come on.
what are the concerns that led to this advisory opinion, and how can we convince maybe people who are concerned about those things that the law is flexible enough to allow lawyers to mediate and serve their clients by selecting the appropriate documents and not getting 3 different lawyers.
Okay, so what was the thing that precipitated this, and what are the concerns behind it? Okay, that's what I mean by my cryptic comment there. Anything else? I mean, there you got one, Pete?
This isn't my field, but off the top of my head, number one, you're serving as a mediator in a divorce, and you have 2 parties, and they know you're a lawyer,
Yeah.
and they want you to draft the documents. Isn't it pretty clear that in their minds they're relying on you for legal advice? Number
I
one.
was hoping somebody would bring that up.
Okay.
Okay, how do we encapsulate that before we move on? Right, how would we encapsulate that? What's the 2-word thing I should write up for that idea?
Well, is it an attorney-client relationship?
Okay,
You know, ordinarily you can stumble into it
okay.
if someone knows you're a lawyer, and, you know, it's the famous thing on the golf course, however you want to say it.
Okay.
Yeah.
And I would add to that what I was hearing, and tell me if I'm right, that's relationship, honest to gosh, that's what it says. What I was also hearing is the question of legal advice from the lawyer mediator. So, legal advice from and I'm going to use the lawyer-mediator.
So
Okay.
the
You had another.
second thing is that if indeed there's an attorney-client relationship, and they come to you as a mediator, that you're going to draft legally significant documents, how much of a duty of inquiry do you have into the circumstances of each party? Do you have to, ordinarily if a client comes in, you want to find out what their assets are, all of this stuff. So if you're going to do it as a mediator, do you not still have that duty? And if you don't do it, are you liable or subject to a malpractice claim when some asset pops out of the wood or something you didn't think of
Okay,
comes up after the divorce?
okay, does that do it? Okay. Anything else? Yeah, Bruce, you have them?
I want to respond to 2 of these.
Oh, can we get the rest of them up and then get into them? Yeah, yeah. You had something?
I have a thought, and I'm not really sure that I've matured it into a coherent question, but it's along the lines of the statement that when you're drafting as a neutral mediator, it's also a lawyer, when you're drafting the agreement, you are practicing law, not arguing that. However, at the same time, I'm wondering about all these times when people do form other agreements contractually contractual agreements, I guess I want to say, where it ranges from the oral agreement all the way to, you know, two people putting something in writing. They're creating a legally significant document, and it seems to me there's a graduation of the amount of law people are practicing on their own and how much you are practicing as a mediator, as opposed to when you are fully representing or holding yourself out as a practicing lawyer.
Okay, so if there's a spectrum between an understanding between two people to an agreement that sets it out to a contract that is legally enforceable to an agreed order for a judge to sign, there's this spectrum, and does that suggest something for what we're doing as mediators?
It makes me want to kind of back off and saying, while an agreement is going to have legally binding consequences, I do really want to question how much it can be viewed as a practice of law.
Okay, okay, so
Or
does the...
I want to qualify.
Okay, so I'm just going to, and again, this is my hieroglyphics for the encapsulation of it. Does the gradation of reaching an agreement have some effect
Some
on this
implication.
question of the practice of law?
I'm still gestating the question, but yes.
Just as a
Okay.
reminder, people are having trouble hearing, so if you could put the mic really close to your face, just so we make sure to get
Okay, anything else? Anything else before we let Bruce get into what he wants to talk about? Okay, what do you got, Bruce?
No, I think it's largely a question of choreography. I don't know how those of you who've done these kinds of things do them here, but in every mediation I've done in my life, you start out by having everybody in the room and you give the spiel. And the spiel is, does everybody understand I don't represent you? I am not representing you. That's spiel part one. All right? And in every mediation, a mediator ordinarily would expect, particularly with represented parties, to get position papers, non-shareable position papers from both sides. Notwithstanding that those papers exist, after the original, you divide. The choreography that I'm familiar with is you take the parties separately. You ask them, why are you here? What would you like to see happen? What is it I can say? What is it I can't say? When the parties in that situation are not represented parties, those separate meetings are longer and earlier in the process. And it seems to me that that's the choreography you need to do, as was asked by Mr. Day. How do you know what's going on? Because that's the place where you get that stuff out. Tell me this, can I share it? Tell me this, can I share it? Tell me this, can I share it? And that's where it goes on. And if during that process you get from one of the parties, I've got this and I've got this and I've got this, and you can't share it, that's the end of your mediation. Now you're sending them to separate lawyers because you are now in a position where you would violate the conflict if you proceeded knowing something about one party's interests and assets that you couldn't share in the mediation and that you brought it to a conclusion. You'd clearly be violating an ethical thing. But I mean, it seems to me that the choreography of doing these things can obviate any kind of an ethical conflict for those reasons.
So let's call it the dance. And isn't life a dance when you get right down to it? And aren't the couples that are coming to us in a divorce in a dance? And so how much do we as individuals dare to engage in the dance, as I said to you earlier, with risk? When do you pull the plug? So what is the standard we're supposed to do this by? Well, conflict of interest for current clients. Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. What's a concurrent conflict of interest? I mean, I'm going to do the lawyer thing here. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client. Well, I'm going to use hell. Well, hell, haven't they come to us because they're a couple trying to separate their lives? There is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. But the key one here is the lawyer's responsibilities to another client. Can't we conceive of the client as the couple? And when might we do that, and when would it be improper? Well, when they've clearly got interests that are directly adverse to one another. Where does that line exist? So now we're doing the professorial hypothetical thing here. B, notwithstanding the existence of a concurrent conflict of interest, all right, so now you recognize that there's a concurrent conflict of interest. Under paragraph A, a lawyer may represent a client if, one, the lawyer reasonably believes, aha, now we're down to a reasonableness standard, that the lawyer will be able to provide competent and diligent representation to each affected client. Two, the representation is not prohibited by law. Well, we're dealing with an advisory opinion, and we're dealing with RPCs anyway. So we're not talking about a violation of law. The representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. That's the old adversarial problem that, you know, we were to strap guns on, shoot down through our cross-examination the other party and their witnesses so that somebody wins in court by a third party making the decision what's in the best interest of justice and the outcome of the case. When here are two people trying to work it out for themselves, and we're there to help them. And four, each affected client gives informed consent confirmed in writing. So that was not discussed. That was rejected. They said it was unconsentable. But how with this was their reasoning, where was their reasoning when the advisory opinion was issued? And on informed consent, a lawyer shall, with communication with the client, a lawyer shall promptly inform the client of any decision of circumstance with respect to which the client's informed consent denotes, and informed consent denotes the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks of the reasonably available alternatives to the proposed course of conduct. Now, doesn't that give us the right to say to a potential client or clients, look, I'm not your lawyer. You may have conflicting interests. I'm going to talk to you a little bit about what some of those might be. They have to do with custody. They have to do with money. They have to do with how you divide your assets. I can't give you legal advice, either one or the other on that. I can give you general ideas of what the law is, and if you have disagreements about that, I may be ethically bound to send you to somebody else to talk about those issues. Maybe that could be an unbundled surface that some other lawyer would then offer, just on that one question that they're struggling with or some portion of it, and then they come back having had that. So what I'm proposing is we need to be thinking more creatively as lawyers. That's what our people out there in the world are asking for now. They don't always want an adversarial solution. And we know in many contexts, mediation works much better. And if I could take one more minute, I just want to put a diagram on the board for us. Just the kind of way that I've thought about this whole question. Let's say down here is kind of peaceful coexistence. And then at being humans, we get angry, the amygdala fires from the back of our neck. We know neurobiologically the lymphatic system fires faster than the frontal cortex, and you're supposed to count to 10, but so many times we never do. We just, our little feeling comes out, and now we're in conflict. And once we're in conflict, we can talk. We can have a discussion. We can slow down, take a breath, talk to our partner, our loved one, our enemy from across the street. Okay. Hard to see on screen? Okay, so this is a hypothetical line. I've tried philosophically to actually extend it into a circle. Haven't had much luck with that yet because everything's happening all at once at one time in our lives anyway. And when we try to break it down, we're doing a logical thing, and it doesn't work logically all the time, as we well know. So down here was peaceful. I'm probably just making matters worse, and then discussion. And then, let's say, negotiation. We kind of get down to, what's your interest, what's mine, only we don't. We take positions to advance our interest, and so we really lose communication because we're arguing over position. You always do this, honey. You always say to me, I not only want you to take out the garbage, but I want you to dance while you're doing it. Be happy, John, be happy. No, sweetie, I'm taking the garbage out, but grudgingly. So we can negotiate over those things. And then if we have trouble with our negotiation, we can go to a facilitator of negotiation who's a mediator. All right. And I'm going to suggest that this is like a fulcrum, kind of like a teeter-totter. Because now, if mediation doesn't work, where do we go? Well, in our cultural system, we go to an arbitrator, arbitration, court, and who's making the decision here? It's out of the hands of the people that have the conflict now. And they have to make up a story that convinces somebody about what happened in the past that has violated legal duties. And so the game starts. The adversarial thing. We used to carry swords and slash each other. And we still do that a lot of places in the world. We've got drones flying over the Middle East as this country now, and we're all upset because people are doing bad things back. But we're at a very final point, which is all-out war, where violence becomes permissible, becomes a tool for, quote, the resolution of conflict. What it really becomes is a power suppression system, and the only reason there's peace under those systems is because somebody's oppressed and is scared to death to say whatever there's truly on their mind and heart. And we may be seeing some of that going on in the politics in the United States right now. So the teeter-totter here is who gets to make the decision. Where are things weighted? And this takes tremendous resource, financial resource, time resource, knowledge resource. Knowledge is power. All of that comes into play up here, and down here it's looser. So that's why I'm challenging everybody in this room tonight to think about that and help us all think as lawyers. Help us all think. How do we move cultural thinking that gets locked up here? Because if we can do it here, and here's where I get on my high horse and my idealism comes through, if we can learn how to do that as lawyers who know about law, I think we start to get at the root cause here that leads to violence and war. Because if we can get people talking to each other, that's really where we need to go in my legal future. That's where I want people to go. So I just want to add that and intrigue your thoughts and minds to come back to us tonight with your own ideas on this thing.
So we have another introduction from an online guest here, Meredith McKell-Graff from Vancouver, Washington. She's the new WMA board member, attorney and mediator in family and elder law. She's practiced in family law for 16 years, and now she practices estate planning and probate. Also, Rena asked the question, what about the interest in creating an amicable agreement? They come to mediation with that in mind. There are no adverse claims. Paul answered, once they reach an agreement, they are not adversarial.
I'm going to try to bridge sort of the philosophical underpinnings that John has given us here in thinking about this to these questions, and to do that by suggesting that I believe that our state bar's committee that wrote AO 2223, I believe, correct me if I'm wrong, it's the only jurisdiction that has come down on this side of the question, that there are 14 state jurisdictions that allow exactly what our state bar's committee advisory opinion 2223 says is not ethical. So the committee decision is on the margins. It's an outlier. And so when we're thinking about what's the alternative, how to make a change here in this state to be able to practice the way that John has described to avoid all-out warfare, how to do that. One state, it was by opinion, I believe, and the other 13, it was by change in the rule. The other weight of authority is the American Bar Association's dispute resolution section has also come down using the model rules from which our rules of professional conduct are fashioned, has come down also with the 14 jurisdictions. So it can be done, and maybe that's the thing to do. And it might be, and I'm getting to the questions, honest to gosh, that might be a way to approach it rather than engaging in a rule-based argument with unstated, unnamed people whom I've never even heard their names or who they are. Who are these people on this committee? I haven't met them. So where does this opinion come from? What are their concerns? We don't know. We can only guess. But the question is, do we engage in, as a community, mediation community of mediators, do we engage in a rules-based analysis and conversation as to whether is this really adverse interests? Are we really representing clients jointly? Are we really engaged in or do we really have a non-consentable, non-waivable conflict of interest here? Or do we change the rule? Comments, questions, snide remarks?
And these things up here that we haven't really gotten to yet, but I spent a lot of time just talking about. Oh, yeah. And we don't want to ignore. Have we talked about what the concerns are sufficiently? I think the concerns are there really are situations that you can get into where the people need separate counsel. You take a situation of division of an estate where you've got retirement funds or separate property that is been now commingled with the community. Just take those, or that the father wants 5 days a week and only wants to give 2 to the wife, and he's going to fight her every dollar to get his way on that issue, or vice versa. Then now you're getting into a territory where you'll recognize that your alarms are going to go off, and you're going to have to say, I can't advise you on those issues. I just can't go there because I'm trying to help you in another way. And if you want to pursue legal issues like that, and I think that's what the concern is. But I think it was with kind of maybe a litigator's background, a civil litigator's background, or a criminal lawyer's background that said, wait a minute, when this gets finalized, they got to live with it. Well, that's true. And it has legal ramifications, but does that mean that you're suddenly representing 2 different people? That's the issue. So does that help at all with the concerns?
Well, I like the way you shaded it a little bit better. And you also made a very good comment earlier, which I'm going to paraphrase as you're more appropriately representing the marriage than you are the individuals. And this is why I kind of look at the gradation of, whether or not you're practicing law, how much law you're practicing, and a lot of it probably relates to the nature of the positions that both parties have. Because I guess where I'm coming from on this is I have a hard time, unless I really understand the policy considerations, accepting wholeheartedly that you can't be impartial. As long as you have fully informed consent, the parties understand the process, the agreements are not unconscionable, there is not any kind of coercive behavior. And you as as the mediator, have to look at what's going on in the process. And as long as things stay in the process where the parties are behaving and following it in an acceptable manner, I think the advisory opinion might be a little excessive. I think part of the job of the mediator is to identify when things are starting to go off the rail and it no longer is a fair process, or the outcomes aren't conscionable or enforceable. And that's when you have to pull the parties back and or pull the plug on the mediation. That's just my two cents on it.
That's a good 2 cents, yeah. Would you grab that microphone?
I just thought I would offer something up from the outer space of California and other places that I've recently occupied. I'm an outsider, and I've been just immersed in Washington State ADR world here for the last 90 days or so, and just recently
Couldn't you keep your
this
voice
opinion
up? Yeah.
came to my attention, and my first reaction to it was, this is nothing to be upset about. The opinion is a well-intentioned relic of old thinking that is fading fast and missed the whole point of the mediation process. I've actually been thinking about the presentation yesterday at the State Bar and all the neuroscience connected with what makes us lawyers and why we have higher rates of depression and suicide and alcoholism. It's because we start out with a gift for thinking pessimistically, and then we're ruthlessly trained to be the world's greatest worst-case scenario preventers. And so when I see an opinion like this, I see that thinking. I see the fear that I saw in the room in the King County Bar Association when we had a presentation on online dispute resolution. And the mediators were afraid they would be robbed of the interaction and the storytelling aspects of mediation when that's not the case at all. I think what should drive this is what John said at the beginning. What do today's consumers want? And if we're too rigid and we resist too greatly the marketplace, then we are going to go the way of the Tyrannosaurus rex and other reptiles. And this is not to be critical of lawyers. This is to be asking questions from a very high altitude. We have the Supreme Court of Washington, the Supreme Court of California, begging for the legal profession to come up with alternative means to serve the community affordably. I mean, if I needed to hire somebody, I couldn't afford to hire myself in California. Professionals and medium-sized businesses can't afford to litigate. People that make a lot of money can't afford to get divorces. So when they've decided, a couple has decided that they want to have help getting to yes, there shouldn't be this kind of, as I say, a relic of old thinking getting in the way. And I don't think it is in the way. And I think everyone just needs to keep doing their job and move forward.
That may capture a lot of the sentiment here tonight. Are people feeling that? Because there is a possibility that we could ask for a reconsideration of this opinion. And have a, and maybe Jeff, you have some points on that.
I don't have points on it, but I wanted to ask Helen if there has, and I'm not, I haven't been part of any conversations about this, about whether within the ADR section and specifically the executive committee, if there's been discussions about of putting together the request that basically Jean Marie Claver encouraged us as a community to make, to revisit the question. She basically, I thought, telegraphed pretty strongly that with the change of the committee structure and the change of the way advisory opinions are now done within the bar, that she suggested that it would be very worthwhile for us as a community to do that in order to address the question and maybe allow the bar an opportunity to bring itself back in line with the rest of the jurisdictions who have read it. So I don't know if there's any news on that. Bruce has got a reaction.
No, I just thought that in preparation for last year's conference, I read the law review article, and I thought it was an extraordinarily effective piece of advocacy for the positions being espoused today. So if that didn't move anybody, I don't know what in God's name might.
Okay. So the law review article, you liked it. You like the idea that they recommend of joint representation, and that the idea of a mediator jointly representing after consent and waiving conflicts? You like that one?
I didn't find that important.
Okay, don't find it important. Okay, gotcha.
I mean, the nature of the advocacy was that the nature of the advocacy was that it doesn't serve the public, and it does in conflict with the law in the rest of the country, and and the piece of and I don't recall what it was because I read it 10 months ago, that the piece of that the language that the committee relied on from some state somewhere was Texas was read incorrectly by the committee. I mean, I believe that was the position of that article. I thought the article should have ended it. That's all.
Just as a little bit of a bit of history, I don't know if any of you folks remember the change in the court rules that came through in 2006, for those of you who were practicing then. But basically, Washington has followed the model rules of professional conduct with, of course, being, as it's once termed, the Soviet of Washington with its own particular changes. And one of the changes that it had, and I don't know when it came into the rules, but it went out in 2006, was it had a title on lawyer as intermediary. And I actually dove into this when I was getting into the rules of professional conduct as a new thinking in terms of being a neutral and a mediator. Okay, could this be a model for bringing collaborative, interest-based negotiation into the legal process by letting lawyers who represent clients also act as intermediaries between clients? This was sort of getting back to when I was a kid working in a law firm. There was a guy with a 3-digit bar number who was advising people, and basically he was the family lawyer, and he'd bring them all into the room and he'd talk turkey to all of them, right? So he was basically advising them all, but did that family of father, mother, sister, did they have conflicting adverse interests in the estate that they might have been contemplating? You bet they did, but he just talked with them about it. So they had this lawyer as intermediary title. So I parsed through what it would take to be a lawyer as an intermediary, and there was like 6 different steps of informed consent, all with written consent that were required, that would have to be made with each one of the parties. It was just amazingly obtuse, and it frankly looked a lot like the particular suggestion that was in the law review article. So I wasn't enthralled with it because I think we tried that. I don't know anybody who worked at it, and now that rule is gone. What I did really like about the law review article that I thought was informative was it put it in the context of this is an outlier decision. It's an outlier as to all the other jurisdictions, and it provided an analysis of why the opinion was not really terribly well written. And that's what I thought was useful to the community here, is what can we do differently, in other words, like the rest of the country is doing.
So we have some comments from online folks. Meredith says, these guys don't seem to know about the team members we use in collaborative law. Of course, we can bring in professionals in finance, parenting plans, etc. Paul says, too many are familiar with the late date evaluative shuttle model and don't think outside of the box. Meredith goes on to say, some of those folks don't know there is another way to mediate.
Sounds like we're missing the real conversation. It's online on this forum. That's, yeah. So Paul and Meredith are talking about how, anyone else familiar with collaborative law, where they bring in a team of professionals, including financial professionals or parenting specialists or coaches to work with to work with the parties, and how that works. So yeah, these are all different things that certainly aren't contemplated within AO 223. Roger.
Well, yes, I've seen that in action. I think it's great stuff. You know, you can go online and look at the Northern California Mediation Center, which is one of the oldest training grounds of mediators in the West Coast. Alan Al-Hadef has connections to it. They have a course coming up in a few weeks that teaches non-attorney mediators and non-family lawyers to do the very thing that AO 2223 says shouldn't be done. And so I'm just asking what's wrong with this picture, and I completely support what I heard from the online comments. And I say, keep going, team.
And here's the thing. I've known about this problem for over 2 years. I haven't written the letter. I've had leadership positions on committees before, and I knew at the end of a discussion like this that if somebody doesn't pick up the cudgels, and here I'm not asking this group to do that, but I'm saying, where do we get the initiative? See, I haven't felt myself personally like the one to do it. And so who is, and how do we get it done? Because the sentiment seems to be that ought to be done.
Can I just note something here? I don't think any of you folks, I don't think any of us here in person in our carbon-based life forms practice in this area. Do we? Do we? I don't think we do. Helen? I know folks online do. What I'm encouraged by is the folks who don't do this think this need to be changed. At least the ones in this room do. So I would think, and I had suggested this, after the last one, I had whispered this to a few folks in their ears because I had just moderated a session, for Christ's sakes. I didn't want to appear that maybe I was biased. I still don't think I am. But if somebody were to take the initiative to put together a request to the ADR section to take a position, and it would have to be probably through their legislative committee, Paul, it would have to be through their legislative committee to suggest either a rule change or a revisiting of the opinion. Maybe you do both, one first and then the next if it doesn't work. If you got this kind of support amongst the people who in the mediation community who don't even practice in that area, I would think that that would be something that would have broad-based support within the section, enough for the executive committee to then take a position, which requires a 75% vote of the executive committee.
And just an additional bit of input about the way the process worked got us into this position with an advisory opinion. A lawyer wrote and asked for an advisory opinion on this topic. And so then a committee of some sort took it up, and probably one person on that committee had the lead, and then wrote an opinion and passed it by the other committee. I'm guessing at this, but that's pretty much the way it works. So maybe it's even simpler. Maybe we've got a committee that does family law. Maybe that would be strategically and politically the place for this question to be raised with the bar. We would like a reevaluation where we've looked at all the opinions and all the other. I don't know how it might be written, but I'm raising that as an issue for all of us to have in our mind. How does this get done? And I know we've got Helen here tonight, who heads up the ADR section. Maybe you have some ideas. We don't have to put you on the spot tonight, but the next step sounds to me like some action to get this advisory opinion reconsidered. Why leave it on the books, so to speak?
Well, I'm happy to bring any ideas to the executive committee. I'm happy to do that. But I do want to point out Paul McVicker has been excellent in leading so many initiatives from our section. He said that he's asked for volunteers to assist in this effort, but he hasn't gotten any volunteers. He says, our idea is to put together the materials, such as the UW article, etc., and simply write to the committee to reevaluate. Oh, and then he says, you don't have to reveal all this. Sorry, Paul. I went ahead and read all that. Meredith also mentions that she's going to bring this up at the WMA board retreat that's happening next week. Rena says, I wouldn't recommend handing this over to family lawyers. We need attorneys with broader experience in mediation.
Consensus among sections in a broad view. Obtaining consensus among other sections, and especially this one, I think would be better than leaving it to any one group. Because this is a phenomena that has to do with a profession writ large.
Yes.
And, you know, how are we going to deliver access to justice in the 21st century affordably and efficiently and in the way the consumer wants it?
Yeah, Roger, I think your point about consensus is right, and I think Rena's comment about being concerned about going first to the family law section is good caution. We have recent experience of how to build a coalition to make a change in innovative ways of providing dispute resolution services, and that was with the UCLA, the Uniform Collaborative Law Act that was passed a couple years ago through the legislature. So what happened with that is there was a base, and it came from the collaborative law community, of course, which wanted this, working with the ADR section, building a consensus there. And who else was involved? Anyway, the coalition was built before getting to the family law section, and the family law section eventually, kind of late, came on board. And then that allowed the bar to take a joint position in front of the legislature, which allowed the legislature to see that the bar was unified and there wasn't concerted opposition. And so that's how it got through the legislature. So I would suggest that eventually getting to the family law section might be helpful, but I would build a coalition first of the folks that are more solidly centered in the mediation community, as our online person cautioned. That's my take.
And Meredith also mentions, she comments, family lawyers killed a proposal for mediation ordered by the court in our county. It was brought to the court by Clark County Association of Mediators in 2008, and it died in the Committee of Family Law Attorneys.
Okay, so there's the caution about how to build a coalition and how to interact with the family law section and the family law lawyers, the ones who are representing. Yeah.
How are we on time?
We're flexible, so if you want to wrap up now.
Are we probably sated and satisfied? Huh? Namaste. Well, thank you all, and thank our online. Thank you, and thank all our online contributions.
Thanks.
So thank you so much, especially those online who stuck through. I know we went over time, but I think we had a really great discussion. And hopefully this really spurs a lot of energy to get moving on this effort. I want to also flag, so next month, we did mention collaborative law a little bit during this discussion. Next month, May 25th is our next membership event. We will be doing it on collaborative law. We'll be working with the King County and Pierce County collaborative law groups. So it will be, again, here at Impact Hub. It might actually be in this space as well. So we're going to work on making sure you can find this room. So we'll work on that. Thanks so much for those online, and thank you for Jeff and John for agreeing to moderate this forum. For those here, please feel free to enjoy the spread that we have out. And you guys online, come next time so you can enjoy this as well. Thank you so much.